Should you attempt to go back to work after filing your Social Security disability application? I'm Jonathan Ginsberg, and I'm a Georgia Social Security disability attorney representing clients throughout the state of Georgia with Social Security disability claims. And I get this question a lot. I filed for disability benefits, I'm running out of money, or I had an opportunity, and I want to try to go back to work. Should I? Well, there are pros and cons. Obviously, the pros are you earn some money. That's important because in a disability case, it can take up to 2 years, sometimes longer, and 2 years without money is a problem, so earning a little bit of money is not a bad thing. I think secondly, it demonstrates to the judge that you are motivated to try to work. You don't have an attitude of entitlement. You have an attitude where you're confronting the idea of being disabled. You want to try everything you possibly can to not be disabled. I think that if you do try to work and you're not successful, which is called an unsuccessful work attempt, that you could possibly get some evidence from your former coworkers or supervisors, basically talking about the struggles you had, the absences you had, the unscheduled breaks, the need for assistance in performing your job tasks. All that is very, very compelling non-medical evidence that can demonstrate to the judge that you don't have the capacity for competitive full-time type of work. So there are some positives with trying to work. The big negative, I think, is that Social Security tends to see disability in black and white terms. And unlike VA disability, for example, where you could be 70% disabled or 50% disabled and collect a benefit based on that percentage, Social Security is all or nothing. Either you're disabled or you're not. And if you go back to work, you're going to introduce some question in the judge's mind, well, this person's able to work and earn $800 a month, $900 a month ongoing. What's to say that if he or she put a little more effort into it or found a job that's a little less demanding, that that person could maybe work full time? That's the risk. Now, the way you get past that, I think, would be with record keeping. And what I mean by that is that when you try to work, you should keep very, very good records about the number of hours you worked and the struggles you had. Here's an example. Let's say that you got a job where you're working as a clerk in a retail store, but you can only do it 3 hours a day or 4 hours a day, but only every other day. You can do it on Monday and Wednesday, but on Tuesday you're so tired and physically spent that you have to rest all day long. That's very different than working Monday and Tuesday for 8 or 10-hour shifts, because if you're working 2 8 or 10-hour shifts, the judge is going to say, well, the reason you're not working more is probably you can't get enough hours. Your employer does not have enough hours for you, as opposed to this is the extent of my capacity every other day for 3 or 4 hours. And I think most vocational witnesses would say that if you have to take a day break after working for part-time, that you are don't have the capacity for full-time type of work. I think you also want to be aware of the earnings, the gross earnings that you receive in a calendar month. Social Security has a concept called substantial gainful activity, and there are several ways that it can identify whether you're engaged in that, but one way is to look at gross income. And for 2020, the gross income number is $1,260 a month. For 2021, it's $1,310 a month. If you exceed those figures, then you have the burden of showing why your work was not substantial and that you should be still qualified, or should still qualify as being disabled. So if you do work, keep very close records, very good records rather, as to the amount of earnings you have in a particular month, how many hours you worked, what you did, any special considerations you got from either your boss or your coworkers. And if you are working at over SGA level, over the $1,310 number, then is it every month, or is it you did it in February, you did it in June, but between March, April, May, you were below that? That can make a difference as well. And again, all these are arguments that your attorney would present in court as to why you were not engaged in SGA. But again, if you are working, you just have to be aware that you are sending a signal to the judge that you have some capacity, and the judge then has to decide, do you have enough capacity for full-time work? Visit me online at ssdanswers.com. You can request my free Secrets to Winning Disability Survival Kit. You can ask for a case evaluation. If you did like this video, please give it a thumbs up on YouTube, like it on Facebook, subscribe to my YouTube channel, and like our Facebook page so you'll be receiving ongoing notice of new videos that I do. And again, if I can be of assistance to you, please reach out to me. Again, my name is Jonathan Ginsberg, and I wish you the best. Thanks a lot.